Assalamu alaikum viewers, you are watching Modest Muse in Review, the lifestyle show where we review the current issue of Modest Muse lifestyle publication. Today with me in studio I've got two phenomenal women. The first is an attorney and the second one is a mobile therapist. So with me in studio our first guest is Hanifa Abdullah. How are you, Hanifa?
Assalamu alaikum, thank you for having me. I'm fine, thanks. And yourself?
I'm great. I'm so honored to have you, and you've written an article in this week's issue of Modest Muse called The Importance of Having a Will. Yes. Now, before I read your article, I must be honest, my will was incomplete, unsigned, somewhere in a safe at the bottom, at the bottom of a whole lot of other documents. And after reading your article, I realized how important it is that I need to get this document updated. So before we chat about a will, please tell us what it is that you do and why you decided to pursue this profession.
Okay, I'm an attorney at Raman Incorporated.
Okay.
Our offices are based in Kenwan. Basically, I do deceased estates, specialize in deceased estates. I've recently I've recently written my conveyancing exam, okay. So we're waiting on the results for that, and once that comes back, inshallah, when I pass, I will be doing property as well. Okay. Further than that, we also do estate matters, which are matters which deal with the poor, impoverished farm workers who are being evicted, and we represent them as well.
Did you always want to pursue this as a career?
For as long as I can remember. I think I may have been 5 years old when I decided this is what I want to do.
Wow, I think you're the first person that actually pursued the career that they knew at 5. I think I changed my mind a million times.
I did change my mind in between, but as I got older, the one constant was becoming an attorney.
So it's definitely a passion.
That
comes through in the article. So now tell us, Hanifa, why is it important to have a will? And I quote you in the article. You say, ladies, 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 3 times. Not only your brothers or your husbands must have a will, you need to have one too. Why did you specifically talk to the ladies? Or do you feel that we as women are a bit negligent when it comes to putting down our estates?
Women in general are negligent when it comes down to their own affairs.
Okay.
It's not so much that the females are incapable of doing things for themselves, but in most instances, females are raised to be good housewives and daughters and mothers, and they forget that they have lives of their own.
We're so busy, and they forget the admin.
They do that. So what we do is, for example, myself personally, I don't have a will, but I know I need to have one. So now I would sit down, look at my affairs and say, okay, I have a house, I have a car, whatever it is whichever assets I have, I now need to ensure that should I pass on tomorrow, it is taken care of. Females generally don't think like that, because I'm married, my husband will see to things. I'm a daughter, my father will see to things. Or if anything happens to my parents, my brother's there to take care of it.
So when do you need a will, Hanifa? Is it when you buy your first home, when you buy your first car? When is it important?
It's important, sorry to cut you,
no
it's
problem.
Important to have a will when you own any asset, even if it's just your first car.
Even if it's financed through the bank?
Still, because you need to ensure that your finances are in order to the point of, should I pass away tomorrow, there is sufficient funds to cover the shortfall that is, or whatever is still due to the bank, for example with the car, or anything that you have. All of us work, we have an income, we have savings or whatever, we have put things in place. So when you have money, you need to ensure that if you pass away tomorrow, that money is going to be given to your rightful heirs.
Okay, so what happens if you don't have a will?
Okay, then South African law will kick in.
Okay.
It's the Interstate Succession Act that governs the procedures and processes that must be followed. So, for example, in the article, I say that when the husband died, he didn't have a will. His 2 wives that he had would now be well, in essence, his family would be disadvantaged, because should his second wife is married to him in terms of South African law, and they've performed a nikah. South African law prevails because we're not living in a Muslim country, so Sharia will not prevail.
Okay.
So because he didn't have a will, Interstate Succession Act applies, and the law is very specific about what happens. So in Sharia, we have proportions that we must follow. South African law also has proportions, but it's all equal.
It's completely different.
So it's very different. So for example, if you should pass away tomorrow, you have a husband, you have children, you do not have a will. The law states that the surviving spouse would receive 250,000 rand of your estate, or a child's share, whichever is greater. So should you only have an estate to the value of 250,000 rand, your husband will receive that, your children receive nothing. Thereby they are disadvantaged.
Is it good enough to have, say, I've got a whole lot of assets, but I don't have the time right now immediately to put it all on a list? Is it good enough to just have a one-line will and say, I am I'm leaving my will to be Sharia compliant, and for all my assets to be dispersed according to Sharia, and have that signed by witnesses?
Okay. The one line that you just used is very important, because you are specifying that your will must, your estate must be dissolved of in terms of Sharia. That is acceptable by South African law. But just that one line signed by witnesses is not going to be sufficient. You would need to follow all the requirements of South African law in order to ensure that your will itself is valid.
So what are those
requirements? You would have to say that this is your last will and testament, that any will that you had done previously, codicils, or any testaments that you have signed previously will be revoked by this last document.
Okay.
So that's the first thing that would be put in there. Everything that all your wishes that you want, if you have a legacy you want to leave, or you want to bequeath your jewelry or your car or a house to any one particular person, you need to specify that. The will must be in writing. It must be signed by yourself, the person making the will, the testator. It must also be signed by witnesses in the presence of each other and in the presence of yourself, and you must also sign in the presence of your witnesses.
Something important I read in your article was that the witnesses can't actually be people who are able to inherit.
Yes.
So, which I didn't know.
So that is the important thing also, which people like yourself don't know. And you need to remember that should you, for example, have children and you leave inheritance to your children, if they are able to witness, or if they witness it, they won't be eligible for it.
And then also in the article you talk about bequeathing, that you are able to, I think I'm pronouncing it correctly, bequeath a third of your estate before the rest, the other remaining 2/3 is dispersed via Sharia. Tell us a bit about that.
Okay, so like the example I used was, you have Auntie Mariam that reared yourself or your children. She maybe is not in a very good financial situation, and you feel that she has done so much for yourself and your children, and you want to give something to her so that when you are no longer there, she'd be able to have a slightly better life. You are then entitled to leave a portion which is limited to 1/3 of your estate to Auntie Mariam, for example. Or if you feel that there's a masjid you'd like to
do wakaf.
A wakaf fund, there's wakaf funds which you could you get the wakaf funds which you could then bequeath 1/3 to.
Okay.
Or you could take the 1/3 and split it in
portions.
You could take the 1/3 and split it amongst more than one person.
Okay.
So like I said, Auntie Mariam would naturally not inherit from you, so you can give it to her. Or if there's even an Auntie Mary who is,
so you
can bequeath your 1/3 to a non-Muslim, or a portion of that. So you could give it to an educational society, or you could say this masjid needs it, that educational society needs it, and this person that I know of, that's a family member, that's not a natural heir, that is in dire straits, they can also inherit. So you take your 1/3 and you can give it to more than one party.
Now tell me, the executor, so the witnesses can't be people who can inherit from the will. Can the executor be someone that can inherit?
The executor is someone that you trust.
Okay.
So, for example, if you feel your spouse is who you want must be your executor, they can be a beneficiary under your will and the executor,
Okay.
but they can't witness it. So
Okay.
generally people would choose an executor and they don't even tell them that you're going to be an executor of my estate. It's just someone they generally trust very well.
Okay, so does the executor have to have comprehensive knowledge about wills and Sharia, or do they generally go to someone that can assist, like you?
Okay, executors generally are people that we trust who are lay people.
Okay.
So they wouldn't always have the required knowledge to wind up in a estate.
Okay.
So depending on what the situation is, they would actually say, they would approach an attorney. The attorney would advise them accordingly, which is usually the instance.
And is there cost involved to the executor, or does the cost come from the person who's deceased from the estate?
All fees, legal fees, advertising fees, whatever is required to be paid must be paid from the deceased estate.
Okay. Last question, Hanifa. Where does tax come into play? Do those that benefit from the will, do they get taxed on whatever they're receiving?
Okay, so for example, if you're inheriting a property, you are exempt from paying transfer duty, which is in essence the tax on the property.
Okay.
So there are exceptions and exemptions rather for tax with regards to beneficiaries, but the estate would be subject to to estate duty tax,
Okay.
depending on the value of the estate as well.
Okay. Fantastic. I've learned so much today, and I'm sure our viewers have as well. Your contact details are at the bottom of the screen should people have any inquiries. Do you have any last words for people out there about their will?
It is very important that they do have a will, and I cannot emphasize that enough, because anything can happen at any time, and your children or your spouse won't be taken care of in the manner which you would have wanted them to be taken care of. So more than emphasizing that they need a will, there's nothing more that I can say on that.
Shukran, it was fantastic having you here, and I'm sure we'll see lots of follow-up articles. You speak about a travel will and other wills going into detail. So we'll see you in Modest Muse in future issues.
Inshallah, I do intend on writing more articles to emphasize on the importance, or rather certain aspects on the wills that we couldn't cover in this particular article, and all further legal articles for important legal matters for daily life that people need to be educated about.
Shukran so much, Hanifa. It's been an absolute pleasure having you here. That was Hanifa Abdullah. Our next guest is Fadwa Kazain. She's a mobile therapist. Have you ever heard of mobile therapy? Join us after the break.